You're welcome back. This is The Law, It's Your Legal Lights and Your Health Law. Let's get to meet our guest for this afternoon, the very first show in 2022. And there is some coincidence. One of my guests may not remember, but I remind her now. My guests are Susanna Asabia Nyampong. He is with T. Forcing and Co. And Augustine Asafoye is with Nkrabia and Associates. So, the very first edition of The Law, which started as Covered and the Law, was with myself and you.
Really?
Yes, and we're starting 2022 with you. Okay, so thank you so much, and welcome to Augustine Asafoye.
Thank you.
Right. So we go to our first segment of the show, very brief, about 5 minutes of it. It's the Law 101, and we are treating Article 22 of the 1992 Constitution. So take a look at Article 22 of the 1992 Constitution. Yes. It says that a spouse shall not be deprived of reasonable provision out of the estate of a spouse, whether or not the spouse died having made a will. Then it continues that Parliament shall, as soon as practicable after the coming into force of this Constitution, enact legislation regulating the property rights of spouses. And finally, with a view to achieving the full realization of these rights, referred to in Clause 2 of this article, spouses shall have equal access to property jointly acquired during marriage. And B, assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. This is the Law 101 for today. By the time we are done with this show, if you did not learn anything, you should have a fair view of this particular provision of the Constitution. So, the next 2 minutes is for Augustine Asafoye, and the rest of the other 2 minutes will go to Susanna. Yes, so what do you say about this provision of the law? How should people understand it?
Samson, we've come from a history. And that is why the Constitution had to take account of it and clarify it. And so it made a provision to establish concretely that where there has been either a matter of death and one made a will, there must be a provision in the will for the surviving spouse. If there was no will, then PNDC Law 101, which will be applicable, will make that provision for that surviving spouse. In the same vein, it is also the right of every individual to also make property. And so the Constitution under Article 18 made provision for individual rights to make property. However, coming into Article 22(3) especially, there has been a lot of judicial discussions, and one doesn't even know whether there has come to a settlement. But then the clarity is that every case is taken on its own account or merit.
Right.
And so the current position, I deduce from the judicial decisions made, is that property that is acquired in the course of marriage, presumably, are jointly acquired property. But where there is clear evidence that it cannot and could not be a jointly acquired property, one cannot force it. And for that matter, it will still be an individual property made by the spouse.
Okay. So, if one gets married, and in the course of the marriage, property is acquired, the law presumes that that property belongs to both spouses.
Yes.
It belongs to the two partners.
Yes.
But as you said, there is opportunity for one to show that even though it was acquired whilst we were both married,
yes,
I acquired it by myself and for myself only.
Only.
Okay. Right. Susanna, what do you say?
Yes. It's been so long since 1992. This will be the 30th year. What I can say, it's quite unfortunate that even though the Constitution says immediately after the coming into force of this Constitution, Parliament shall pass a law to regulate the property rights of spouses, it's not been done. I know several bills have been sent to Parliament, but this hasn't materialized. If it had, the uncertainty and the judicial decisions that Augustine mentioned wouldn't have been much of a problem. But we would pray and hope that parliamentarians will take notice and get the right thing done so that this can be brought into effect. Then spouses can actually know and will not have to rely on the Supreme Court decisions as to their rights under the laws of Ghana. And that will be spectacular.
Right. But we are also aware of the Lands Act 2020,
yes,
in which they have tried to make a provision that tries to take care of this situation, that property, when it is acquired during marriage, it is presumed to be
joint
for the two husband and wife,
Yeah.
unless the contrary intention is shown.
yes.
Okay, thank you very much. So that has been our law, the Law 101 on Article 22, clauses 1 to 3. It says, a spouse shall not be deprived of a reasonable provision out of the estate of a spouse, whether or not the spouse died having made a will. Augustine explained that. So if you didn't make a will, the PNDC law 111 will take care of the situation. And then it says that to achieve the full realization of this right, a spouse shall have equal access to property jointly acquired during marriage. Equal access to property jointly acquired during marriage. Assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon the dissolution of the marriage. When the marriage is dissolved, it will be distributed equitably, equally, if it was joint property. Thank you very much. Now, we will treat our legal clinic for today. We will attempt to give you a summary of the issue that our viewer has sent. It's a very tall one, but we are trying a small summary, and then I guess we'll look at it. The parties, there's a man and a woman, and they are resident in the UK. They got married customarily. Their marriage is by customary marriage, which you know in Ghana, and were represented by their families during the marriage. Both parties were themselves not physically present for the marriage. You are familiar, this thing happens once in a while. The parties never cohabited. They didn't live together in the same house, and there were no children to the marriage. The man, however, had 3 children from his 2 previous marriages. So this is a man who has already married before 2 times previously, and is getting married to this woman, but in this marriage, it is customary, but the 2 of them are absent. At the time of marriage, the man had acquired some properties personally, both in Ghana and in the UK, and no other property or properties were acquired during the subsistence of the marriage. Upon the death of the man, the woman caused to be executed by her brother and another a statutory declaration naming her as the head of her late husband's family. The funeral expenses were taken up by 2 of the children. The woman returned to the UK immediately after the funeral, forced the doors to the late husband's house in the UK open and made away with all his personal belongings and effects. He even says, including boxer shorts.
Yeah.
She has since been using the statutory declaration she obtained to take away all her husband's properties in the UK. Despite losing a court case she instituted in the UK and was asked to pay hefty costs, which she couldn't pay. She has started another procedure in Ghana to claim her late husband's properties in Ghana. Okay. Before the husband died, he discovered that the woman's previous marriage in 1990 was never dissolved before they contracted the customary marriage sometime in 2010. And in fact, that she has 4 children from that marriage. The late husband has always made it clear to the woman and family in meetings that his properties belong to his children, and was about to make a will in furtherance of that before his sudden demise. As a matter of fact, one of his children assisted him with loans to renovate his only property in Ghana, as he was on retirement at the time and had promised to pay back. In the light of the fact that the properties the woman is trying to lay her hands on were acquired decades before she met my late father. It's okay. She met that husband, and the fact that the man died intestate. What legal rights are available to his children to stop her from getting a part of those properties in Ghana? Do the children have a case to stop her from laying a hand on the properties acquired before they met, if there is evidence and witnesses to prove the same? Well, in this narration, we have just illustrated 2 issues, but the case appears to have a lot of issues. So let me begin by asking my guest here, what's their summary of the issues that come up in the case brought to us by Nana? The case was brought to us by Nana. So we hear first from Susie, and then we hear also from Augustine, before we go into the advice or solution.
Okay. So from a cursory reading of the problem, we have issues of marriage.
Right.
There's a customary marriage. There was an ordinance marriage which apparently hadn't been dissolved. Those are some issues. There are issues about who is entitled to property. What are the children entitled to? What is the wife entitled to? There's also an issue of the child having put in money in the father's property,
right.
Someone else getting it. There are a few others mixed up in there, but I would want us to concentrate on at least a few so that we can give something cogent.
Okay.
And
so your areas of concentration for which you will give advice to Nana are?
On the marriage, the sort of marriage that was contracted, if there was a marriage actually.
So the question is whether the marriage was valid or not valid.
Valid, yes.
Okay,
there's
and
that
2?
One. Then there's also the issue of the entitlement of the child or the wife as to the property.
Right.
Yes.
This wife who got married to the man later,
yes.
That is after the man had had 2 previous marriages, and this woman who has done a statutory declaration, you going around with it to take the property from the children.
Yes.
Whether she is entitled to the property.
Yes.
Okay, and then your last point, your last area of advice will be, so these 2.
So let's stick to these 2. I'm sure as we're going on,
right.
more.
So let's hear Augustine Asafoye.
Yes, in addition to what Susie has mentioned, for lawyers, we also look at the validity of the statutory declaration.
Okay.
We also look at the validity of marriage in terms of the customary marriage, in terms of proxy marriages.
Okay.
Then we also look at
that's this marriage where none of them were present.
Yes.
But they used other individuals to represent them.
Yes.
Okay.
We look at that one also. Then we also look at entitlements as to who can even apply, because she said she had, the lady had taken steps to claim the property of the man.
After getting a statutory declaration, she's now started a process in Ghana.
Yes.
Right.
So we look at who is capable of making such an application for letters of administration.
Okay.
Then I think so also the application of Article 22
of the Constitution,
which is also applicable, although discussed.
All right. So, since both of you agree on the question of the validity of the marriage, can we start from that point?
Yeah.
Why are you questioning whether the marriage is valid or not valid?
So let me start from here. Under customary law, per Ghanaian customary law, and I may not be aware of each person's customary law, but necessarily let's use Akan customary law since that person is called Nana. Mm-hmm. Marriage by proxy is allowed. It's legitimate. Under normal circumstances, if the persons are not there and the families are there to accept the incidence of the marriage, yes, it will be taken. It's a marriage.
When you say incidence of marriage, what do you mean?
So, there must be the agreement of the parties. They must agree they want to be married. That is the main thing in a customary marriage, that both parties are in agreement and want to be married. And the families must be present as witnesses. So you can't go hide somewhere in a little corner and say, I'm getting married. Right. It's not valid under customary law. And you can't force someone to get married under customary law under our laws. So yes, that marriage is valid. However, they also mentioned that there was a previous marriage in the 1990s which hadn't been dissolved.
For this lady?
For the lady.
Okay.
Now,
where she had 4 children.
Where she had the 4 children. Now, the issue arises because under Ghanaian law, a woman, even if she was previously married under customary law, cannot contract another marriage under customary law without the first marriage being dissolved. Now, that is with customary law. Okay. A man has a different whatever, but those are our customs. Now, it even becomes worse if it's under ordinance. Under ordinance marriage, if the marriage is not dissolved by a court of law, and you contract any other kind of marriage, be it customary, Mohammedan, or ordinance, that other marriage is not valid. So if this lady had not had her previous marriage, whether customary or ordinance, dissolved, and went ahead to contract another marriage by customary law, even if it was by proxy.
With Nane's father.
With Nane's father. That second marriage is not valid.
Augustine.
Yes, I'm looking at it from this angle. First and foremost, customary marriage has what we call the essential validity of marriage.
Okay.
And there are 4. One is that the parties that are marrying must agree that they want to live as husband and wife.
Okay.
That is not enough, because according to Olenu, marriage and customary marriage is a marriage between 2 families. That is the man's family and the woman's family. So essentially, it is not even about the 2 couples. That is the 2, the lady and the woman.
Yes, so you are cementing further what Susanna just spoke about.
So essentially, it is about the families consenting, and the man's family consent by agreeing that the woman will be accepted as wife of their son.
And the drinks that are brought
and they also
taking...
present what we call tinsa. Then also the woman's family also accepts the tinsa to also admit the man as the husband of their daughter.
All right.
So beyond that, and that is also material, particularly in this matter, where the final essential validity is that there must be cohabitation. Cohabitation initially was construed to be that there must be like a sexual intercourse between the husband and the wife. But one cannot see them actually do it. So what?
So cohabitation means what? Living together.
Living together.
Okay.
So now that's consummation by cohabitation. Initially, it was consummation, where it was only to do with the sex. But how were we to prove it if the two people don't come and see? But once we see them as living together, then the presumption is that there has been that consummation.
Okay.
So we say consummation by cohabitation. But in this matter, from the facts laid to us
By Nana.
There has not been any cohabitation.
Right.
So it therefore means that the customary marriage, as we are even looking at it, in terms of the essential validity, they haven't reached the threshold.
So the marriage
is not valid.
You are not even talking about the previous marriage by the woman.
It is secondary to it, because once the customary marriage is not even valid, then you will not even consider.
So the two of you agree that this marriage is not valid. The woman was previously married. She had 4 children with the previous man, and she came into this new marriage by customary marriage and had not dissolved that one.
Yes.
Right.
I wanted to add, if the customary marriage was to be, let's say, presumed to be valid, in my view, considering the facts also laid to us, because he who alleges must prove. The facts indicate that they do not have evidence, though they know, or because the father before death told them that he's found out that the woman's marriage has not been dissolved yet.
And it was by ordinance.
By ordinance. And so, but the one who is giving us the facts does not have any evidence
to prove that. Okay.
And so if he is to go to court to establish the nullity of the marriage, he will have problems. He cannot succeed.
Okay. Because so he will not have to raise that one
at all, because it will be difficult to prove. He will have to push for.
Yeah. But your point is that they can establish that this marriage is not valid because they didn't live together.
Yes.
Thank you. Now let's move to the next point. You say the next point, you want to put it under the rubric of the properties, whether the woman is entitled to any of the man's property and so on and so forth. So take us through that.
Okay, so I'll work on an assumption.
Okay.
Now, and there will always be the issue of whether she was a wife. So I'm going to work on the assumption that she was a wife. An assumption. Now,
that is even after you.
I know she's not.
Assessed her under the law.
I have assessed her under the law, and I do not believe she's a wife.
Okay.
But I'm going to argue on the premise that she is a wife, just to show what she is entitled to, even if she were a wife.
Okay.
Now, it's been said he died intestate. So law 111 applies.
Died intestate means what?
Died intestate means died without leaving a will.
So the man died without making a will?
Yes.
Okay.
So he didn't have a will. So he didn't determine who should have his properties. And so the law determines it for them.
Okay.
Now, before the summary of the facts, I had certain issues. And I asked the question to myself, was he even Ghanaian? Because we know so many of our people who have moved out of the country and have changed their citizenship and no longer keep their Ghanaian passports.
Okay, he said that he was going on retirement, and he had said that he wants to retire and live in Ghana.
Yes.
So he was getting ready to do that when he died.
Yes, and I know a lot of people who want to come back to Ghana yet have given up their Ghanaian passports.
And to also think that he has his family here in Ghana.
Yes.
This new woman also has her family here in Ghana, and the family came together to contract the marriage.
Yes.
We can presume that he is Ghanaian.
We can presume.
Okay.
But I'm also working on the very thin possibility that he had given up his Ghanaian citizenship. Because there are quite a number of people out there who think that because they retain ties to Ghana, they remain Ghanaian.
All right.
It is the passport that makes you Ghanaian. So people out there, try as much as possible and be a real Ghanaian and not a Ghanaian in name only.
Okay.
So I'm working on those assumptions, that he is Ghanaian, even those are other ones, and that she's a wife. Under Ghanaian law, for a person who died intestate, the wife has an entitlement, the children have an entitlement, and the family has an entitlement. What the law says is that they define a matrimonial home, which is the house the man and the wife and the children were living in at the time of death. That matrimonial home can be changed.
That's a nuclear family.
Yes, a nuclear family. Now, they are entitled to the matrimonial home. Then all other properties the person has is divided in certain ratios, with 3/16 going to the wife, I should say the surviving spouse.
It's 5.
9/16 going to the children, and the remaining 4/16 going to the family. So practically a quarter of the estate ends up with the family. Now, she's gotten some statutory declarations. I really don't know how that one came about, going around like she's the head of family, not even the wife. Even if she's able to prove that she's the wife, she still is only entitled to a smaller percentage of the man's estate than the children, especially as the properties were acquired before the marriage. Now, if the properties were acquired jointly, then you could say that her portion will be taken out and the man shared. These were properties that were acquired by the man alone.
And that says the properties were acquired like 40 years before this marriage.
So this is his personally.
And this man had 2 previous marriages with children in those marriages.
Yes.
And she is coming in with her 4 children from the previous marriage.
And I must mention also here that her 4 children do not enter the equation.
Okay.
They are not the man's children. They don't enter the equation. They have no entitlements in law. She only has an entitlement if she's able to show that truly she's a wife. And I know Augustine said a matter of proof. But if they're able to give enough evidence to show that she might have been previously married, it would fall on her to show that that marriage had been dissolved.
Okay.
And you can go through several iterations. But I'm going to work on the premise that even though I don't think she is a wife, working on the premise that she is a wife.
Right.
Even if she is a wife, that is what she's entered. She can't just take everything over. She can't do that and all.
All right. Now, we take a quick break. When we return, we'll hear from Augustine Asafo-Adjei. You've just been listening to Susanna Asabia-Nyampong of T. Forson & Co. And my other guest is Augustine Asafo-Adjei of Nkrabea and Associates. We'll be right back to continue providing advice and solutions to the problem brought to us by Nana. Be right back. You're welcome back. This is The Law. My guest, Augustine Asafo-Adjei with Nkrabea and Associates, and Susanna Asabia-Nyampong with T. Forson & Co. And we're providing advice and legal help to Nana. He and his family are in a difficulty as to questions of property and the validity of a marriage that was contracted by their late father, who died shortly after. And in this marriage, he had made his properties about 40 years before, had 2 previous marriages, children in these marriages before he married this new lady. And in this new marriage also, they didn't do it, the 2 parties being present. They just asked both families to come together by proxy, and they got married. Right, so we are now on the question of the distribution of property and whether or not this woman has a right to any of the property of the man. and Susie has clearly demonstrated her portion of it, more particularly that the woman, her 4 children from the previous marriage don't come close at all. So where do you take it from here?
Yeah, something. When it comes to interest in property, especially coming from marriages, it can be cagey because there are 2 schools of thought. Where a marriage has even been declared a nullity, it does not affect the property interest of that party whose marriage has been made a nullity, so that the person can still make a claim in the property. So that one, it is for the court to evaluate, considering whether or not the person can have an interest in the property, especially when it comes to divorce. In this case, the fact tells us that the property was acquired way before the marriage.
Right.
So that the issue of jointly acquired, presumption of jointly acquired property does not even arise, because the property was not even acquired in the course of the marriage. It has been existing before. Now that the person is dead, and now we are looking at whether or not the person is a wife and also should have an interest. The issue of whether or not he is a wife has been determined, and we do not think that she is a wife. Similarly, when it comes to the property, not being a wife, she does not have a claim in the property. She is going about with statutory declaration to more or less say she is a wife. It is provided in the Statutory Declaration under, I think, Section 5.
Where Declaration Act.
Yes.
Okay.
Where it is an offense for you to make a deposition which you know is fraudulent. So that if somebody goes about with a statutory declaration where it contains fraud, which is known to him or her, but he decides that that should be what he wants to go about town with, the law can catch up with him.
That's a crime.
Yes, it's a crime, and it's a misdemeanor.
Okay.
And in this provision under the Statutory Declaration Act, the law did not provide for the punishment,
okay,
the maximum or the minimum. It only said it's a misdemeanor. So in that circumstance, you will come back to the Criminal Procedure Code, Section 296, Section 4, to find out what kind of punishment. And the law says that the judge can grant or jail the person for up to 3 years.
Okay.
So that should be known to the client.
Yeah, so that reminds me, in the first circumstance, if it is established that she had an ordinance marriage and then she came to contract, she had not dissolved that, and then came to contract the customary marriage,
Yes.
There's some crime also there?
Yes.
A crime of bigamy. Okay. All right. Now, we are talking statutory declaration. She was holding a statutory declaration. What is that?
Yes, statutory declaration is a form of affidavit, but the law says that an affidavit is used before court, maybe for an application or a proceeding or something that you need an order of the court, so that it is supposed to be put before the court.
All right.
If it is not to be put before the court, then you do what we call statutory declaration. Essentially, both of them are affidavit, but one before the court is what we call affidavit,
okay,
and one not to be put before the court is statutory declaration.
And what does it do? What effect does it have?
The lawyers will say mostly it is self-serving,
okay,
but importantly, it is to tell the whole world that a certain fact, so far as you know, is true.
Okay.
And if I may add, it is sworn before a commissioner for oaths, under oath.
Okay.
So if you tell lies in there, perjury will look at you.
Okay. All right.
Because you're practically lying under oath.
Okay.
In addition to the property, there's also an issue where the fact also says that the man at a point in time made oral depositions or declarations that some of his property should be shared in a certain manner
for his children.
and that he was planning to come to Ghana to really come and do a will.
Right.
But because of the sickness, he could not do that because he had to travel from the UK. So that there is a suggestion of non-occupative will or samanso in our local parlance, where we do oral will. So that it is the law, so far as our law is concerned, admits non-occupative will or samanso, provided it meets certain conditions.
And that there is a will, even though it's not been written down.
It's not written. It's oral. That we are here, and because of my condition, health condition,
I can't write a will. I can't sign.
Yes, and I cannot get the services of a lawyer.
Or I can't even have the opportunity. The time will not allow me.
Will not allow you. So what you do is you do an oral will, and the law says that it is admissible, provided that when you come, the sickness that you are suffering is over, and you come from, let's say, wherever you were locked down, and you come out. The very moment you come down, within a reasonable time, you should be able to convert it into a proper will.
Okay.
Otherwise,
into writing.
Yes. Otherwise, it will become invalid.
Okay.
But if you are unable to come, and now the unfortunate situation happens, that is, you die.
Many people make this on their deathbed.
Yes.
Okay.
Once that happens, then certain requirements must happen to ensure that what you have said, which are your intentions, should be enforced. Those essential things the law requires of us is that, one, the property must be yours.
Okay.
And two, when you made those depositions, there must be at least two witnesses who must not have interest in the property. At least two. They must not have interest in the property. If they will have interest in the property, it will mean that deposition will not, or declaration will not be made valid.
Okay.
Thirdly, in exceptional circumstances where two people, you cannot have two people, but only one is available. Still, considering your position, your situation, the law can accommodate it. So those are the things. But of all importance is also the fact that at the time that you are making those declarations, you must be sound. You must
have a soundness of mind.
Yes.
Okay. So is it the suggestion to Nana that whilst the father was by his sickbed, on his sickbed, and was telling them this, and he said there were witnesses there who saw and heard everything he said about the property, and even the one that he said he should take care of, and he used part of his money to renovate and everything, and where he had the intention of even paying him back the loan, but he kept saying, well, the property will be for you and your brothers, so I don't even have to pay you back and all of that. Does it mean that they are capable of going to a court to say that their new mother, quote unquote, is not entitled because their father actually made a will, even though orally, samanso, and distributed the property the way he wanted?
Yes.
Is that the point you are making?
Yes.
Okay. All right, thank you very much. This is The Law. It's your legal light. It's your help law. And my guests are Susanna Asabia Nyampong. She is with T. Forcing and Co. And Augustine Asafoye is with Nkrabia and Associates. They've been helping to go through a very tall letter sent to us by Nana. And there are so many issues in there, but they have managed to distill the issues, and this is the advice that is being offered. We have a very short time to conclude the show, so you can get in. It may be a similar situation or something different, but we are happy that you have something to say or question to ask around what is being discussed. And remember, the Law 101 was on Article 22. You may also ask around this area. So the lines are open now. You are at liberty to join us with your suggestions and questions. we know that in providing solutions to Nana, many people may have similar situations and are getting their answers through that. Whilst we wait for our audiences to join us, I don't know, because I've seen that you guys have written a whole lot about this thing. So if Nana were sitting right in front of you in your chambers, what would you tell Nana?
Well, the first thing I'll tell Nana is we get as much evidence as possible to build a case. He shouldn't say because of money he doesn't want to continue.
He said he's drained.
Yes, it's unfortunate. I'm sure the case in the UK drained him financially. But he also can't allow her to, for example, use the Statutory Declaration or her status as a wife to come to Ghana, apply for letter of administration. She might not even put the correct facts in there. The courts would have no way of knowing otherwise, and she might use those means to take the property.
Second time you have mentioned letters of administration, and Augustine also mentioned it. What is that too?
So letter of administration, the court documents, the law makes you have them. Now, so let me break it down a bit.
Okay, so just hold on. Mark is calling us from Insom. Hello, Mark. Let's hear you.
Yeah, my name is Mark. I'm calling from Insom. Please, I'm listening to your program, and in your discussion, you have been saying that when the property is acquired jointly, when the property is acquired jointly, and the man dies or one of them dies, we share the property. But if
Go ahead.
Yeah, but if the man or if one of the parties only acquires the property without the contribution of the other, will there still be joint? Will it be shared?
I think your question has been heard. Thank you very much. Augustine will address your question, but you were educating us on letters for administration.
So the law requires that once a person dies, there must be documents to enable you to administer their estate. It actually is a crime to go interfering with somebody's estate without these documents from the courts. So if the person left a will, there's something called probate that gives the executors the right to go into the property and work with it. On the other hand, if the person died intestate, the court issues what we call letters of administration. That gives some people the right to administer. It doesn't make the property theirs.
Okay.
It just gives them the right to administer the property.
Okay. Ablo, you are calling us from Lashibi. Let's hear you, Ablo. Hello, Ablo. Ralph, you are calling us from Nungwa.
Yes, please. My name is Ralph. I'm calling from Nungwa.
Ralph, go ahead.
Okay, sir. I have a similar situation. My father died intestate.
We are listening.
And my elder brother.
Yes.
My elder brother was claiming that all the properties that our father had in Accra here belongs to him because he found his name on the indenture. Now, we went to court, and he claimed it was a gift to him by my father. So the judge asked him whether there were witnesses and all. He said there was no witnesses and blah, blah. So the court said we have been able to rebut his claim. Actually, we won. But he appealed again.
We have very limited time, so you should be snappy with it.
Yeah. So he went for an appeal, and on the grounds that since his name was on the indenture, the property belongs to him. And I want to find out whether we still have. I want to find out whether we have.
Okay, I'm sorry. Thank you. Because the matter is pending in a court, we cannot make any comments on it. I'll take our very last call because time is almost up and we have a question to deal with. Juliet, you are calling us from Sinyani. Hello, Juliet.
Hello.
Hello,
Yeah,
Juliet.
Hello, can you hear me?
Yes, go ahead.
Please, my question is, if I have a boyfriend, we are not married, and then we have one child. So in this case, if I die, is the man entitled to my benefit? That's just my question.
Okay, thank you very much, Juliet. That's where we end the call so that we can continue. Yes, the first caller's issue.
Okay, the first caller's issue is where a property is acquired by only one of the spouse, whether or not it's a jointly acquired property. The issue is, like I said, it is a presumption which must be proven. It's a presumption on the basis that sometimes you alone acquired a property, but what was the intention even behind the acquisition? If, for example, you acquired a property with the intention that it is going to be your matrimonial home, by that intention, it becomes a jointly acquired property because you intend to put your other spouse in that property. So he will have that interest.
Or, for example, you acquired a land and the other party contributed to build, the property on
property.
Okay.
So all those things are, that is why Poor Mind said in Fin and Fin that though it is a presumption, it needs evidence. And that is why we also indicated that every case is determined on its own merits.
Okay.
So that the presumption is there, but it still need evidence to establish it.
Okay. Yeah. So, what do you say to Juliet?
Oh, so Juliet, your boyfriend is not entitled to your personally acquired property. He's your boyfriend.
She's also equally not entitled to
his.
But the child.
Will you correct me? Poor Mind JSC.
Yes.
The child belongs to both. So the child is a child of both parents and is entitled to whatever properties both parents have.
Okay.
But because they are not married, the incidence of Article 22 does not apply to them. It's for spouses, and that is very clear. Now, maybe the Act in future might consider the rights of boyfriends and girlfriends or people who just cohabitate. But as of now, sorry girlfriends, sorry boyfriends, you're not entitled.
One sent a message saying, in the case of property sharing between the children of different women, which of them will take the large portion of the property? The man died and added all his children to the property.
Yeah, it's supposed to be equal shares. They're supposed to hold it as tenants in common. And customarily, I know that they share it according to wives. So each wife has a share. But in normal law, that is not it. They're supposed to hold as tenants in common.
Even where he says the man added all his children to the property, suggests to me that a will was made.
Well, maybe.
Okay. Our time is up, and I can't thank you enough. Augustine Asafoeje of Nkrabia and Associates, and Susanna Asabia Nyampong of T Forcing and Co. This has been The Law. I'm Samson Ladi Anyanini. It's your legal light. It's your help law. God willing, next week we come your way with another edition of The Law. If you have any issue, send an email to samson.ladi@myjoyonline.com. There's no P in the Samson, and Ladi is Lardy. Have a good afternoon.